Hello, everybody. Welcome to today's compliance update from Orange Tree Employment Screening. My name is Jeff Ernst. I'm the Vice President of Sales and Marketing, and I'll be your host for today. We have Heidi Seaton, who is our VP of Legal and Compliance, and she will be the keynote speaker for today's session. A lot of things going on in the compliance world, a lot of updates today. I touched base with Heidi ahead of time, but a lot of important things to keep track of. So without any further ado, we'll just get right to it. A couple of things about today's webinar, just a few things right here that you can refer to. The webinar is being recorded. We can't capture your thoughts. You don't have to worry about that. There will be a handout made available. I think it's already in the Zoom toolbar. If you have any issues whatsoever, occasionally that happens, no big deal. Just let us know and we will send you the deck for your convenience. If you have questions, ask them. We want to make sure you get out of this seminar, this webinar, what you're looking to gain, and you can submit those in the Q&A icon within the Zoom toolbar, kind of along the bottom of the Zoom panel. We will, immediately following the webinar, be sending out a communication so you can receive your SHRM FCRA educational credits. And also in that same email, possibly too, there will be a link to today's webinar. So if you, for any reason, maybe have to dart out and handle a call, or you want to share it more importantly with a colleague, you'll be able to do that. So a couple of things on Orange Tree, for those of you who may not be familiar with us. We like to call ourselves the no compromise background provider, because in addition to a full service suite of background services, drug testing, occupational health services, our clients have told us that it really kind of gets down to three things that they're looking for. They're looking for technology, has to work within their ATS, you have to have a candidate experience, et cetera. You need to have it right. The data has to be right. We have to be following reasonable procedures. That's why Heidi's here today, and she represents really the cornerstone of everything we do here, which is compliance. If it's not done right, if we don't have the right processes, I can assure you it doesn't find the light of day. So everything is compliant. And then finally, all of that is fantastic. And then there are times you have questions. There's times you need to reach out, find out what's going on. Maybe you need some additional packages to what you're trying to accomplish in your background screening program. We have the client care that you deserve. Just a highlight here today, because we have a couple of technology updates. This is really an overview of the technology that we provide for our clients. It starts with ATS integrations, where we'll talk a little bit about that. We have a wonderful mobile experience for candidates to keep them engaged, get them through the process on average a day faster than others in the marketplace. I think that's pretty important in this day and age when you're trying to find people and put them into your seats, your training classes on Monday morning. And then a variety of other things that you might expect along the way, adjudication tools, an amazing and easy to use portal, as well as a full service suite. For those of you who have an HCM, maybe you want some additional data about the process, where we'd be delighted to provide that to you so you can get an end-to-end assessment of your hiring process. Then a couple of things that you see the icons on the wings of the chart. We are PBSA accredited, have been since 2011. A lot of details that go into that are to your benefit. And we are right there at the forefront of being accredited with PBSA. And then on the right side, you see the SOC 2 certification. So all of these stringent IT standards that you would expect us to meet, we do. So just an update on integrations. That's always first and foremost to our clients, those who are engaging with us. You want to know, who do we integrate with so you can be more productive, most productive with your recruiting staff, talent acquisition teams. And here's a good list. There's others. Just gonna want to highlight a few because we've had several new here this year. One, we have Healthcare Source, CTM, their contingent talent management solutions. We're excited that one is going live. Also, Fountain is another one that has been live here for a couple of months, off and running. We're really excited about that partnership, as well as JobBite. So those are there. We have a couple of more coming in the second half. The chart's getting a little bit busy. I may have to reduce the size of those logos, actually. We have Paradox and Workstream in the workflow. So more to come from Orange Tree. Having our own technology team, our own technology platform really puts us in control of helping our clients get what they need. And let's face it, there's a study not that long ago, about 100% of the market is changing ATSs, and that seems a little bit extreme. What do you mean by that, Jeff? Well, 41% just did change, and 49% are planning to change in the next 18 months. So you're probably on that list. And I think even in this day and age, you're looking for maybe more than one, depending upon your use case, depending upon your business organization. So just know that we at Orange Tree can help you get through that process. The candidate experience still is very important to talent acquisition, to your candidates as they get through this time called the background screen. They have higher expectations and ease of use and being informed along the way. As you look at the icon there on the left of a real screen of our Candidate Connect platform, it's kind of like the pizza tracker of the background screen business. It keeps the candidate informed about what's going on, very easy for them to interact with and get through the process. Most importantly for you, it keeps them engaged so that they keep moving along and they get the information that we need so that they can get through the process. And it gives them the information they need as well as we have a phone number that they call us instead of you. So once the background check starts, for all intents and purposes, you can go back to what you do best, which is filling open positions. And then we do what we do best, which is conduct the background screen and get your candidate through that process. They call us for help. And we have a little bit of fun. We've enabled this capability for our clients to customize their splash screen. This is a sample of some recent clients. And we look forward to putting your logo and your color patterns onto a splash screen in Candidate Connect sometime soon. Just one more data point or set of information on our candidate experience. As I mentioned, we care for your candidates so you can keep doing your job. And we answer virtually almost all of the calls live. Occasionally leave a message, you call them right back within 2 hours, the same great response that we give to you, we provide to your candidates. And the average talk time, pretty short. We get to the point, we help them through the question that they have. And it's a very highly rated experience, very easy. That's a candidate perspective to us on a survey that we conduct at the end of our surveys, or the end of our background screens, I should say. So just where are we going to be over the next several months? It's kind of exciting, at least we think it is. Hopefully you share that enthusiasm. The conference season seems to be coming alive here again for the next several months, including the National SHRM in Las Vegas on September 9th through 11th. You can get a complimentary expo pass by using the Orange Tree company code E365. For those of you in the upper Midwest, in the frozen tundra, I promise it's only fall in October. I don't think we'll have snow. I think. So we are going to be at the Minnesota SHRM down in Prior Lake. So for those of you who you can't make it to Vegas and you maybe want to take advantage of some of that entertainment opportunity, join us at the Minnesota SHRM in Prior Lake at Mystic Lake Casino. Hey, you can get the same thing here, and if you're in Minnesota, maybe you don't have to travel quite as far. We do have some additional opportunities in the remainder of the year. ISIMS has a conference there in November, and UKG Connections is hosting an in-person conference. A little bit late in the year, kind of interesting to see it in December, but boy, if you're going to be somewhere in December, why not be where it's going to be warm and predictably sunny in Las Vegas with all that great entertainment. And so, on that topic, I'm going to transition this over to Heidi. She's going to take you through the compliance portion, the highlights of today's webinar. But as you can see, we're asking a poll question. What are your plans for the National SHRM Conference this year? It looks like people are not participating.
Jeff, I may have removed it from the screen there for a second. They should be able to see it again.
Oh, people are still participating.
Okay, good.
Well, here's Renu. We're gonna have to do something about this, because what people may not understand, or maybe you do and you just can't get there. Hey, I'm not telling you what to do with your time. I'm not doing that. I do want you to know, however, if you are in Las Vegas at the SHRM conference, you want to find Orange Tree at our booth. We are, like we did a couple of years ago at the last live conference, raffling off Louis Vuitton bags, and that was a hit. Boy, it was fantastic. I had no idea that it would drive the type of enthusiasm and excitement that it did. We had fun. The winners had fun. I think people just watch it. The whole process had a bunch of fun. So make sure if you're there, you stop by, look us up. We'd love to see you. Heidi?
Great. Thanks, Jeff. Can you hear me okay?
Can hear you great.
Okay, great. So welcome, everyone. As Jeff mentioned, my name is Heidi Seaton. I'm VP of Compliance here at Orange Tree. A lot of you come and listen to me or spend some time with me every quarter. I try to do this update on about a quarterly basis. So for those of you that haven't spent time with us before, we just try to spend this time looking at some developments in the background screening space, especially as it relates to new laws, new regulatory advice or guidance that's coming out, and then a little bit on litigation in the space. So I do just want to remind everyone, I'm not your legal counsel. I'm not counsel for Orange Tree. My experience is in background screening. I've been in the industry for about since 2008, and the last 10 years really focusing on legal and compliance issues. So that's the experience I sort of bring to bear in this discussion, but a reminder to seek your own, the advice of your own counsel if you have specific legal questions. Moving on from that, here's our agenda. Again, following a pretty standard, or what's become standard agenda in these quarterly updates, we'll talk about things we're seeing, especially on a state and local level, for ban the box, for fair chance regulation, and salary history bans. Sort of newer to the space, we'll talk about court access issues and some privacy, state privacy statutes that we're seeing. We'll talk about litigation. We'll do a little bit on drug testing updates, especially again, states, and then we'll wrap it up. We might have time for questions today. As I mentioned to Jeff, not a ton new since the last time we talked. A lot of this is updates or reminders. So a few things though are really important updates and reminders. So stay tuned. First thing, just a reminder on Alabama. So we talked about this when we met in July, but it was very new at the time. Alabama did pass their Redeemer Act, which decriminalized some misdemeanors and nonviolent felonies, especially related to drug use, personal drug use. And it also made some of those past misdemeanors and, again, nonviolent felonies eligible to be expunged. Unlike some states, here in Alabama, they do require a petition to the court for that expungement. So if you have a candidate who tells you that case was automatically expunged under this law, probably not. Probably they did have to go through a process to get that expunged. So there might be some surprises there. That went into effect here in July. And as most employers in background screening know, generally expunged records are not going to be included in your background screening report anyway. So this will be a little bit, the net effect here will be, you just may not see records on reports that you might have seen before if they have actually been expunged under this new law. So that's a trend, by the way. So we are seeing more and more states move forward with these updating statutes to decriminalize, again, especially drug offenses, especially personal or individual drug offenses, and especially related to marijuana or uses of small amounts of drugs. Waterloo, Iowa. So you may remember we did talk about this last time. And at the time we had a pending court case or a pending state Supreme Court opinion. That did happen in July. So the background on this one, again, the city passed an ordinance with a July 1 effective date. That says 2020, but it was 2021. Sorry about that. It applied both to public and private employers in the city of Waterloo with 15 or more employees. And the argument there was the city couldn't adopt an ordinance that had terms or conditions for employment that exceeded or were in conflict with state or federal law. And there is state law in Waterloo. And so the issue there was that there was the belief that the new ordinance was in conflict and required more. Sorry, I'm going to move this a little bit. So we did finally get that decision in late July. Unsurprisingly, it was sort of a split decision. They affirmed it in part and nullified part of the ordinance. They affirmed the part of the ordinance that said that it applied to businesses of 15 employees or more, and said that the ordinance was constitutional, was allowed to limit employers' ability to ask job applicants about their criminal history They said you can't do that. They affirmed you can't do that as a Waterloo, Iowa employer until a conditional offer has been extended. But they nullified the section of the ordinance that would prevent employers from making decisions solely based on an applicant's criminal record. So that's probably good news for employers, gives them a little bit more leeway in how they make those decisions related to use of criminal history information in Waterloo. In Louisiana, a reminder, I just talk about this one because it was fairly new when we discussed it in July, and it did have a really quick effective date. So that went into effect here earlier this month. This was fair chance legislation. So again, a reminder, fair chance legislation is related to ban the box. Ban the box was legislation, or is legislation that, at least initially or historically, required employers to remove the question about criminal history from the employment application and to, but then would allow the employer to ask that question later on in the process. Fair chance sort of layers on to ban the box in that it usually has language or requirements for the employers then how they use criminal history information once they're able to ask about it and do that criminal background check. So Louisiana here, with the August 1st effective date, it does apply to any employers, public, private, with 20 or more employees in the state. And it says employers can't consider arrest records or charges that didn't result in a conviction. Again, not terribly controversial there. Most employers aren't looking at arrest only case information. For other employer or other criminal history records, employers have to complete an individualized assessment of whether the criminal history has a direct and adverse relationship with the specific duties of the job. And then it gave specific considerations or items that the employer has to take into consideration when they're doing that individualized assessment. So the nature and gravity of the offense, the time that's elapsed since the offense, the conduct or the conviction, and the nature of the job sought. So as you're hearing those factors, this should sort of ring a bell with EEOC guidance. This is similar to the guidance from the EEOC, but the guidance from EEOC generally is enforcement guidance, right? Here we actually have the state bringing that requirement to do the individualized assessment, to take those factors into consideration, building it into the statute, right? So binding statute for Louisiana employers. Employers are, the statute also adds additional rights over and above the FCRA, the Fair Credit Reporting Act rights to consumers. In Louisiana now, applicants have the right, or consumers that you've done a background check on, have the right to make a written request for any background check information used during the hiring process. So potentially that's broader than just the background screening report being prepared by your consumer reporting agency, by Orange Tree, right? So potentially that request, or that right to make that request, and then the employer's obligation to provide this information could go to, for instance, if you have if your recruiters are doing a social media search, right, as part of their pre-employment screening, maybe even pre-background screening process, then you'd want to be thinking about processes like that when your Louisiana applicants or consumers make this sort of request for any background check information used during the hiring process, because it probably is intended to be more broad than what's required under the Fair Credit Reporting Act. Note the FCRA, the Fair Credit Reporting Act's adverse action requirements obviously still apply, right? So you still have to do, if you are considering not hiring someone based on the content of that consumer report, you're going to want to do that 3-step adverse action process where you're doing a pre-adverse notice with all of the content of that notice and the copy of the report and the summary of rights document going out to the consumer. Your second step is to wait, right, to give the consumer a reasonable amount of time to get the copy of the report, to confirm whether or not there's anything in the report that's inaccurate or incomplete and potentially initiate a dispute. And then if there is no dispute, there's a final adverse action step as well. So a layering on here in Louisiana, again, I would say comports with the trend, right? We're seeing more and more state and local legislation and ordinance creating that's producing more obligations for employers. We're not seeing that being reduced in general. And then just for state employment, if any of our listeners here are part of a state agency, already had that requirement to not ask about criminal records until after the interview. So again, a layering on a second generation, even if you will, of ban the box and fair chance legislation moving through states. Maine, this is new, right? We haven't talked about this yet in this forum. So they passed ban the box legislation that was in early July, set for a October 18th effective date, applies to private employers. And this new ban the box legislation in Maine says an employer may not request criminal history information on the initial application or at any time prior to determining that the applicants are qualified for the job. So again, a little bit different language here. They're not in Maine requiring employers to wait until the conditional offer is made, but pretty late in the process, right? So otherwise qualified. So probably you're down to one or two applicants there before you would be allowed to ask the candidate about their criminal history and or before you'd be allowed to actually initiate the background screening report if it includes criminal history information. As some of them do, it has exceptions for state and federal laws or regulations that are mandated for employers that say a criminal conviction would disqualify an applicant for a position. And then just a reminder, there was already a 2019 bill here that that prohibited questions about criminal history on an application form for state government employees. So this, again, a layering on here, there was already an effective statute for state government, and here now in 2021, we're seeing it now come to comply or apply to private employers as well. New York City. So I think we had at least a discussion about the New York City update at the last session. It's significant, and there was guidance that came out right before the effective date. So this regulation was passed, or ordinance was passed in December of 2020 with a July 28th, 21 effective date. And then the New York City regulators issued new regulatory guidance for employers on the 15th of July. So less than 2 weeks before its effective date. And it's a tough one. It covered a lot of ground. If any of you are New York City employers and you haven't read this guidance, I would urge you to do that. Let us know if you need a link to it. 28 pages of guidance for employers or affected employers in New York City. And it's expansive. It covers a lot of ground. So firstly, it limits what records the employer can consider. So it sort of removes from consideration things that are not criminal, that are not convictions. It comments on some deferral adjudication programs and employers' consideration of that information. And then a lot of time is spent in the ordinance, in the guidance anyway, on the timing of the criminal portion of the background check. And I get questions. I've spent a lot of time talking to clients about this over the last month. Very often it doesn't make sense to employers. They're like, why is the city requiring this? And I think just based on my analysis of both what they've published and just what I'm sort of hearing, as that there's a perception that in New York City, an employer does the background check And then if there's anything in the criminal portion of the background check that they decide they don't want to move forward with hiring that person, instead of sort of owning up to the fact that the employer is considering that criminal history information, they withdraw the offer based on some other criteria. Again, this is only, I have no evidence to believe in New York City employers are actually doing this. This is just based on my reading of the guidance and some other interactions. But so what they've done with the guidance is basically told employers, they've redefined the term conditional offer of employment in New York City to limit it basically to say a conditional offer of employment in New York City is an offer of employment that can only be withdrawn under two circumstances. One, where there's some medical or health reason that the job needs to be withdrawn. And two, where there's a criminal history information or where there is criminal history information that is associated with the job that the employer is using to make that decision to withdraw. And so what that means for an employer is that employers have to do any other pre-qualification of their candidate, like verifying education, employment, potentially doing a drug test, doing a professional license, anything non-criminal. And the exception to that is a driving record. So we'll get into that. So education, employment, reference, professional license, potentially drug testing, all of that has to happen before the conditional offer is made, or before the conditional offer is made, so that when the conditional offer is made and the employer then requests the criminal background portion of the background and then gets potentially criminal history information, it's clear that that's the reason why the employer is withdrawing the job. Right, so that's the intent, I think. So what we see in the guidance for New York City is that timing is absolutely everything. So they require this sort of do all your general qualifying of your applicants up front, do any non-criminal or non-driving portion of the background check before the conditional offer of employment. Then if the consumer is still qualified, if the applicant's still qualified, then move forward with your conditional offer, make your inquiry into criminal history, including potentially asking the applicant if they have a criminal history, and then doing the criminal portion of the background check, and then making a decision based on that. So sort of now a at least two-step process for many New York City employers. And I just take the opportunity, and the guidance does as well, to remind employers, even so when you're doing the background check, that does not include the criminal or the driving portion, so sort of the pre-offer portion. Remember that the Fair Credit Reporting Act still applies, right? So you still need to make a disclosure about the fact that you're doing a background screening report. You need to get the candidate's authorization to do a background screening report. The guidance from New York City tells employers to not talk about the fact or existence of a future criminal check as part of that pre-conditional offer non-criminal background check, to only talk about a consumer report and defining what a consumer report is, and to not mention the fact that a criminal record search might be done in the future. Then for the second step, when you actually get to that step of running the criminal background check portion, again, the Fair Credit Reporting Act still applies. Employers should be looking at then, okay, does my disclosure that I made as part of that pre-conditional offer background check, does it meet all of the FCRA requirements about being standalone and clear and conspicuous? Is that at that point, do you want to actually talk about the disclosure, that part of the background check, including criminal history information? Employers in New York City have the Article 23A notice. Employers in New York have the Article 23A notice that needs to go out as part of the disclosure and authorization process, so before the background check. So that still applies here at this step. And then New York City, even before this guidance, so with basically the 2019 New York City law, New York City had created a fair chance form process. So this is a form that New York City employers, if they're considering withdrawing an offer or taking an adverse action based on that criminal history information, needed to do sort of an individualized assessment with the consumer and laid out what factors the employer had to consider. And they had created a special form where the employer would basically document that process, share it with the consumer as part of their fair chance process. So the New York City, the fair chance form process has not gone away with this new regulation. In fact, the form's been updated, and now there's two different sets of factors depending upon whether the criminal history information is for a conviction or for a pending case. So New York City employers pay attention to this one. It's big, it's kind of ugly, and it was fast, right? It was the expanded regulation, what I think is an expanded regulation, was just issued in the middle of July with a July 28th effective date. So if you haven't looked at, if you're a New York City employer and you haven't looked at your process there yet, now is a good time. So that was a long time on New York City, but it's kind of a big one. Federal updates. So last time we talked about the Workforce Justice Act. This was to be an amendment to the Omnibus Crime Control and Safe Streets Act. This would have tied federal funding to states and tribes for local law enforcement, prosecution, defense, to the state's passage of ban the box legislation. It got referred to committee back in May, I think, and hasn't moved. So it has not moved from that subcommittee, and the House recessed. The recess is expected to be cut short, but I still just don't really foresee this one making too much progress in this session, in this coming session. Salary history ban. So a little bit different than ban the box and fair chance here. And we haven't seen a state pass a salary history ban in a while. There were a number of states that had previously passed in the last few years salary history ban. So basically a salary history ban is a statute ordinance that says employers, in your background screening process, you can verify employment history, but you cannot collect information about your applicant's history of salary with their past employers. And more importantly, you can't use that information in your decision about either hiring or retaining or making an offer or determining salary of that applicant. So we had a new one that just passed here in Nevada in June with, again, kind of a quick effective date here coming up in October. This one specifically says employers may not seek the salary history of an applicant for employment, rely on salary history to determine whether to offer employment or rate of pay, or discriminate in the form of refusing to interview, hire, or promote based on refusing to provide salary history. So in this case, by the way, most states built an exception that said, hey, if your candidate voluntarily discloses it, then you can use it. No exception here. So Nevada employers, be careful about training your recruiters and hiring managers to not ask for it. And then if they do, if that information is disclosed, help them try to find some way to exclude it from their salary and offer process. Moving on from salary histories, we've got a couple of slides here on access, and we're talking here about court access. So you may remember if you attended the session in June, we had an issue with Michigan. The court had implemented a rule to redact personal identifiers from court records that were made accessible to the public. Was particularly problematic for background screening for employers because what happens when you remove personal identifiers from court search terminals especially is that you're left with basically doing a criminal record search at a court using a name, right? And a name only search can produce many false positives, right? So you'll get records, at least, so your researcher, your background screening company, and that's the employer, could potentially get records for candidates or applicants, consumers that are false positives, right? It's a name match, but being unable to confirm any other identifiers means you can't exclude them necessarily. So very problematic, was causing all sorts of delays at the courts in Michigan, because the alternative then, when this information or this ability to search gets removed from public terminals, is that then researchers have to submit those requests to confirm the identifiers to the court clerks, which means the clerks were being basically inundated with requests to confirm records. So the PBSA, the Professional Background Screening Association, did some really significant lobbying there. Some of our employer clients did some lobbying there, and we did have good news in late June there, with the court postponed the rule and to be effective January 1 of 2022. So we're really hopeful that we can continue to work with those court administrators to make sure that when they do get back to implementing the court rule, that they do it in a way that doesn't impact employers' ability to get criminal history information for their applicants for employment. So that work is ongoing. It was nice to get a little reprieve. We got a little time to continue to have those conversations with the courts. So we're hopeful about that one. Soon after, almost at the same time, we have a similar issue in California. So there, in that case, in California, there's a court rule that says that prohibits the display or publication of date of birth or driver's license information in a court calendar, register of action, or index. Historically, that a rule still allowed for date of birth and DLs to be used as part of a search filter, right? So it wasn't like a researcher would go into the court and just search, on a date of birth, or search on a name and then use that to find a date of birth about that candidate. It was a filter. So you put in the name, and then you also enter a date of birth or a driver's license number, and that filters out false positives. There was then a case it's about statutory interpretation called All of Us or None of Us versus Hamrick. And the California Court of Appeals held that public searchers may not search for or locate records by inputting an individual's known date of birth or driver's license number. So really problematic, right, for public researchers in California, for employers, especially in California. The impact, of course, there was some district courts in California began removing the ability to include a date of birth as a search identifier on their online portals, which again, similar to Michigan, is driving this requirement to submit all of those name matches, where it's just a name match, to clerks for confirmation, which is overrunning the clerks. So courts that have removed those searches right now, Alameda, Fresno, Kern, Riverside, Santa Clara, Tulare, Ventura, Yuba, LA, San Bernardino. So far, we're still having good success with clerks being actually willing to confirm records, but it will and does impact turnaround time. And so we have, again, the PBSA had submitted an amicus brief filed in the case, basically saying, this is a complete misunderstanding of the court rule, right? The court rule never said that date of birth, needed to be a search, that you could only search by date of birth, or that you could search a name and then use the public records that resulted to find someone's date of birth. That was never how the public terminals worked. And so just trying to sort of bring a little sanity back into that decision. We're hopeful, we just heard today that the court is considering that petition, but they did today grant them an additional 30-day extension to consider the petition. So we now have a 9/30/2021 deadline to have the court weigh in on that decision. Could happen sooner. For that matter, they could give themselves another extension. But we're keeping a close eye on that one, just because California is obviously a giant state from a population standpoint. Lots of public record searches going on in that state just based on population alone, and so it'll be important to get that squared away. More on that next quarter, I'm sure, and there'll no doubt be blogs about it when there is a decision on that petition. So moving now then from court access to privacy. Just a reminder, again, we talked about this last time, Colorado now was the third state to pass comprehensive privacy legislation. The CPA goes into effect, we've got a few years, right? So you've got Colorado businesses have a couple of years to come into compliance with this one. It's applicable to controllers that conduct business in Colorado or produce or deliver products or services that are target Colorado residents, and a couple of other criteria. It does have a carve out for information being collected by a background screening company, a consumer reporting agency, and for employment records. So that's good news for employers on the employment side, and does create a new right for consumers. They have the right to access, correct, delete, and obtain a copy of personal data and opt out of processing for targeting advertising. So no private right of action in that one. We'll see if there's amendment to that statute here before it becomes effective in 2023. That could certainly happen. Oops, that's a duplicate slide. Sorry about that. On the FCRA litigation side, again, last time we talked about this Ramirez v. TransUnion case. This was scheduled to be argued, and that actually did happen here. Sorry, no, actually it was argued and we were just waiting on a decision after the last one. So we did actually get a decision in Ramirez. The background here on this one was background screening company, I should say consumer reporting agency, credit bureau, had reported an unmatched OFAC record. So that's the Office of Foreign Asset Control, government data database, basically. In that case, the named plaintiff of this class action lawsuit actually had his credit application denied based on that unmatched OFAC record. And the court certified a class of 8,000 in that case. And the question became whether it became a standing question, so it said Article 3 in the Federal Rules of Civil Procedure permit only provide standing where the majority of the class or where the class suffered harm. So the question here in this case was whether Article 3 and the Federal Rules of Civil Procedure permit a damage class when the majority of the class suffered no actual harm, because there's 8,000 unmatched names in the CRA's system, but only I think about 1,000 of them had ever actually been reported outside of that consumer reporting agency's database. So the holding there, so this was the exciting news that came out here in June, July. Holding, just a reminder, citing from Spokio, right? So that was the last US Supreme Court opinion we had on background screening and FCRA questions. They said, again, every class member must have Article 3 standing in order to recover individual damages. and class member standing must be shown at every stage of litigation. So again, citing from Spokio, they said the mere risk of future harm standing alone cannot qualify as a concrete harm, at least unless the exposure to the risk of future harm is in itself causes a separate concrete harm. So the new test under Ramirez is, in order to confirm standing, a risk of real harm must either materialize into actual harm or cause some independent harm. Good news for defense side of class actions, especially under FCRA. It'll be harder with this decision for these giant classes, unless each individual class member was actually harmed. So good news, but I do think, and the industry watchers comment on this as well, that potentially we'll see plaintiffs refile or move into a state court under state law instead of relying on federal rules of civil procedure for class action. Drug testing. So surprisingly, not too many updates here, not terribly surprising given the time of year, but just a reminder, in Connecticut, their recreational marijuana law was signed June 22nd with a July 1st effective date, although they will need a regulatory scheme to implement it, so probably won't actually become available until mid-2022. Legalized the use and cultivation of recreational marijuana for individuals over 21. Employers, it said, could still maintain a drug-free workplace policy and implement policies prohibiting possession, use, or consumption, subject to some exceptions. And then it did say employers can't discharge, refuse to hire, or otherwise take adverse employment action against an employee or prospective employee based on the individual's use, cannabis use outside of the workplace before that person became employed, unless doing so would cause an employer to violate federal contract or lose federal funding. Tough one there on the pre-employment side for a Connecticut employer to continue to test for marijuana, or at least to continue to consider a marijuana drug test result in Connecticut pre-employment without some other state or federal law. DOT employment, of course, would be carved out here. So definitely something for a Connecticut employer to be thinking about. Let's see, next one is New Jersey. Again, reminder, this was a voter initiative, became effective, becoming effective next week, so 8/21/2021. This was a recreational marijuana law. It removes marijuana as a Schedule I drug and legalizes it for adults over the age of 21. Explicitly protects employees who engage in off-work marijuana use from an adverse employment action taken on the basis of that use, and limits an employer's ability to act on the basis of positive marijuana test after employment started. So that's post-accident reasonable suspicion. Still, employers can maintain a drug and alcohol-free workplace. Employers don't have to accommodate use or consumption or being under the influence or possession while, or sale or growth while in the workplace. Employers can still have policies prohibiting use or intoxication during work hours. Does unfortunately require an impairment recognition expert certification to come. And I haven't seen that certification, by the way. New Jersey employers should be paying attention to that new requirement. New Mexico, an update. This was signed into law by the governor in April of this year, became effective June 29th. Legalizes recreational marijuana for individuals 21 and older. so it indicates how it must be ingested, right? Smoked, vaporized, or ingested in a cannabis consumption area. The statute does not prevent or infringe on the employer's right to adopt and implement a zero tolerance policy regarding use of cannabis products. Note, they don't use the word applicant in the language, so question there about whether or not that was intended only to limit employers post-hire drug testing. The statute does explicitly still allow for adverse action for possession or use of marijuana in the workplace or during work hours based on the employer's policy. Can't restrict the rights of medical marijuana participants. So this recreational marijuana statute does not affect the rights that medical marijuana users already had. And then it also, as I mentioned, really early, these drug testing laws very often include decriminalization or expungement provisions for drug cases, especially individual or personal use. And then South Dakota, we again left this one in a pending state last month, and it's still in a pending state. We're still waiting for the South Dakota Supreme Court to make an update. We thought that would happen here before the effective date in July, but it didn't. So we're still waiting on that. So the the medical marijuana law did go into effect. And the recreational marijuana is the one that we are still pending the Supreme Court decision on. So more to come on that one. And then Virginia. So again, just a reminder, as the timing on this one was close to our last session, this was recreational marijuana legalization for adults 21 years of age and older, effective at the beginning of July. Again, employers are permitted to prohibit the presence of marijuana on their premises within the boundaries of the law. They're allowed to fire employees who are impaired at work as a result of marijuana use. The medical marijuana use was related to the use of cannabis oil. So interesting specificity in the Virginia law. Employers are still permitted to take adverse employment decision action if the performance is impaired by use, and they can prohibit possession of cannabis oil during work hours. And there's exceptions, again, to comply with federal law. And that brings me to the end of my slides and my prepared comments. Jeff, was there a question or two that you wanted me to try to respond to, or?
You know, I don't see any questions today, Heidi. It looks like
Okay.
you have.
I was 100% clear.
100% clear. Congratulations. Congratulations. And you're talking to some very talented, bright people who track with us probably. So we are going to continue our tradition that we started a couple webinars back. We are going to conduct an Apple Watch drawing. In fact, Ray New, our director of our marketing manager, has actually already done the drawing. The only rule, this is kind of a thing, is that you have to still be with us in order to win. So let me just make sure I've got the list of it, and there we go, so I can compare it. So she gave me the names, and the first name that she drew was Kelly with us yet. Oh, Kevin, so close, but so far there is not a Kelly Farmer with us. So we will move on to number 2 on our list. Is Laura still with us? I should probably have her new helping me, Heidi, or whatnot. Nope, Laura, I wonder if he'll watch the recording. Renew, don't delete this. Leave this as part of the recording. I'm sure people, it'll go viral, I'm sure. All right, without any further delay, the next individual is Nicole with Nicole. Nicole is with us. Do you want to share in your excitement, Nicole? Maybe Nicole's just sitting out there, stepped away to refresh her
Taking
pop
it in.
and download her link to share with her colleague. But she's online. Everyone, thanks for joining this quarter's compliance update with Orange Tree Employment Screening. Thank you, Heidi, for the complete, thorough, and clear update as always. And for those of you who are interested to get a review from a no compromise background screening provider, Orange Tree, be happy to help you take a look at your program and see if there isn't something we can do to give you a little bit more than what you're getting today. Thank you very much. Have a great day, everybody.